Hey everybody, welcome back to the channel today. We've got some updates for you on the Boland v. Bonta case and hopefully a little bit more context to really wrap our heads around this lawsuit, where it's going, and possibly even some time frames that we can give you. To discuss it with us today, we've brought on Alex Frank, who is an attorney with Michelle and Associates. He's been working on this case from the very beginning. Alex, thank you for being with us today.
My pleasure. Thanks for having me.
Absolutely. So before we get into the questions, however, I did want to let you guys know it's really been helping. The subscriptions that we've been getting, the views that we've been getting, this information is getting out there. We're almost reached our goal to 10,000 subscribers, and you can continue and help us get there. Be sure to drop a subscription, drop a like. It really helps with the algorithms so that this info gets out there, and we really appreciate you guys and your interactions with us through these videos. So jumping into this, Alex, so we've been keeping a close eye on the Boland. The decision just came out. The judge put a stay on his own decision for 14 days. Can you go ahead and give us the update, of what recently happened? We've been waiting to see if the state was going to appeal it, and it looks like they have. So what exactly are they appealing, and what's the process moving forward?
Sure, happy to explain all that. So we moved for a preliminary injunction. So a preliminary injunction motion is basically a request to get the court to give you some relief immediately on an expedited basis while you adjudicate the rest of the case on the merits. So in this context, what that means is that we said to Judge Carney, please prevent California from enforcing certain requirements of the roster regime that we have here while we adjudicate the remainder of the case. So we said, basically, the standard there, legal standard, is that we just have to show a likelihood that California's roster law, or at least the subdivisions of it that we challenge, are likely unconstitutional. That's the standard. It's not a full-blown determination that they are yet unconstitutional. It's just, given the shape of the evidence right now that we can present to the court, is it more than likely that this law is unconstitutional? And if it is, then you should prevent California from enforcing it in the months between now and when we ultimately resolve the case on the merits. So we had luck on our side. We prevailed, and we secured that injunction. That came out last Monday. And at the same time that the injunction was issued, which is pretty common in cases like this, Judge Carney stayed the injunction from having an effect. That's all a stay is. So ordinarily, when an injunction is issued under the federal rules of procedure, the legal effect becomes operative at the moment that the order is issued. We all learned that with Freedom Week back in 2019. But in this case, a stay basically prevents that from happening and says this is not going to have effect until a date in the future. In this case, that was 14 days. So the reason why Carney did that was to give the state of California some breathing room to figure out whether or not it's going to appeal and to go ahead and ask either him or the Ninth Circuit to continue the stay during the pendency of their appeal of the preliminary injunction motion. I know that was a lot of legal language there, but I hope it made sense.
Yeah, no, I mean, that makes sense. And, I don't even know if Freedom Week ends up being a catalyst for this. I don't know if we'll ever see a decision just go directly into effect again after the craziness that was Freedom Week. It was good craziness, right? But I feel like that did kind of set a precedent there. So, okay, so we've got to stay for 14 days, but, at the end of the day, the judge did, take our arguments and say they're valid, right? And we argued specifically on the chamber loader indicator. We argued on the magazine mechanism as well as the microstamping. So the state comes back and they do what? I mean, they appeal it to the Ninth Circuit. What does that have to do with the stay? And what is the timeline going forward from there?
Sure. So the order that Carney issued enjoins the state from enforcing three aspects of the roster, which are the chamber load indicator, the magazine disconnect mechanism, and microstamp. Now, what the state has done as of yesterday is they have filed a motion with the Ninth Circuit, and they're asking the Ninth Circuit to keep the stay that Judge Carney issued in place Only as to this, the chamber load indicator, the CLI, and the magazine disconnect mechanism, the MDM. They are not asking the Ninth Circuit to do anything about microstamping. So this coming Monday, microstamping is no longer enforceable in the state of California. But the Ninth Circuit may keep the CLI and the MDM requirements enforceable pending the appeal. So we have briefing that's due on Thursday to basically oppose the state's request and to essentially allow none of these three features to be enforceable pending appeal. And if that's the case, then manufacturers will be able to submit their firearms for the drop safety and the firing reliability testing, which are still going to be operative requirements to roster admission. But that basically means that all of the semi-automatic handguns that Californians haven't been able to buy for over a decade, the only thing that stands in between Californians being able to buy those and is basically the administrative process of getting these guns certified. Now, we don't know how the Ninth Circuit's going to rule. It would be amazing if the Ninth Circuit denied that and said, look, we're just not going to grant that motion. But it's hard to predict what the Ninth Circuit's going to do. You know, how this motion will resolve. Is likely going to depend to some significant extent on, you know, which judges we drop, because when you go to the Ninth Circuit for anything, you get a 3-judge panel, and that panel is randomly assigned. And there's 52 judges on the Ninth Circuit at the moment. It's a mix of, you know, it's a mix of appointees, right? You have Trump appointees, Biden appointees, you even have some Richard Nixon appointees, and everyone since then. So it's a mixed bag. If we get a good panel, we could be in great shape. And as soon as next week, we could be seeing manufacturers submit guns for the testing and get roster admitted, which would be amazing. So right now we're working on that briefing. It's due shortly. We'll get a quick ruling on that. That will happen shortly. And we hope, at least we hope it'll happen shortly. Probably will. Probably happen in a few days. And that's an unusually, you know, quick way for things to happen, but it works that way in this scenario because of the emergency nature of the relief that the state is requesting.
Well, and I'm assuming also, you know, if they're working within the timeline of the 14-day stay that was put on the decision, the state waited an entire week to appeal it. So, I mean, they would probably be aiming to do that this week regardless, right? So that the law doesn't come off. I'm kind of curious. We have received a little bit of feedback. Obviously, there's a lot of excitement going on because these three items really were the teeth of the Unsafe Handgun Act, right? You know, if you've watched The Armed Scholar this week, I thought he put this really well. I wanted to get your take on it. You know, you have these three components that we attacked in the Unsafe Handgun Act, but that's not everything that really goes into the roster. There are a couple more components. I was just really curious, you know, in the decision-making process and in figuring out, you know, how you were going to attack this as a law firm. You know, what were the processes that you went through to determine these are the things that we need to attack to give, you know, obviously the most benefit to citizens in California?
Sure. Well, I hesitate to even call it a legal determination because, I mean, I've been shooting for most of my life, for 20 years. And I remember when the roster came online, and I remember reading the law when it came online. It's Penal Code Section 31910. And, you know, in the early days of the roster, the early requirements didn't really stop manufacturers from selling the newest models, right? It was really only when the CLI and MDM became operative, and then when Microstamping became operative, that those three features working in conjunction are the reason why we can't buy anything introduced to the broader national market since May of 2013. So just as a shooter who, you know, walked into a gun store and wanted to buy a 2011 or a Shadow 2 or something cool to shoot in competitions, I wasn't able to because I look at the features that it must have and it doesn't have them. So, you know, we looked at it and we thought, in reality, you know, there's really these three features of the roster law of the technically it's called the Unsafe Handgun Act, right? Those three features are what prevent us from buying the stuff that we want to buy, right? That's what keeps all of the new modern stuff that's come out in the last decade unavailable to us, right? It's because manufacturers aren't building guns that have chamberlain indicators because people don't want them. Same for MDM, people don't want them. And microstamping doesn't exist. It's been proven to exist in a laboratory in the context of a few models of guns, but it was never shown to be adaptable or implementable to any firearm. There's no evidence that every firearm maker in the world can take the technology and implement it in their guns. And that's really what prevents us from accessing that stuff. So we, just as a shooter, right, I looked at the law, and I think virtually everybody who's looked at it since then looks at it and says, yeah, it's these three requirements that are the problem. Now, yes, there's other requirements under the roster. And I'll clear that up. So even if we win everything that we asked for in this case, there will still be a roster because there will still be other requirements that we didn't attack. And those requirements aren't going to prevent anybody from getting a gun admitted to the roster. I can't find a single gun that any California would want to buy that's been introduced to the broader national market in the last 10 years that you're not going to be able to buy if we win what we win here in our case. Now, it would be amazing if there were no roster whatsoever, if there were just like it was in like Arizona or Texas or any state that isn't hostile to gun rights, that has good gun laws, where you can just walk into a gun store and just buy whatever you want without there being kind of administrative process that gun makers have to jump through to get their guns approved for sale. But in reality, what's left on the list is not going to stop any manufacturer. There's some fees, there's a drop safety test, and there's a firing reliability test that no modern gun is going to fail. So while it may be viewed as an inconvenience, we're in California. We're in the nation's laboratory for gun control. Politicians in Sacramento would rather pass gun control laws than focus on any one of the other serious problems that society is facing. It's unfortunate, but we get the leaders we deserve, and that's reality. So we have to work in the reality that we face, not the reality that we want. We just have to be realists about it. And there's another roster case out there, the Renna case, and they're trying to strike down the entire roster, every word of it. And that's ambitious and that's wonderful, and I wish them success. But we decided to try to go for what we consider to be the biggest obstacles that would likely survive the test, right? The Bruin historical scrutiny test.
And and that's fair. You got the things that are actually keeping the firearms from coming in. And I actually liked the way the decision was written. The judge basically came out and said, there is no gun in existence that meets all of these requirements. One of the things that's being brought up as a concern would be, California's law that as firearms continue to go on the roster, some of them come off. I think that sort of nullifies this lawsuit would kind of nullify that as well, though, right? Because, under that law before this lawsuit having its victory, those firearms that are grandfathered in don't meet the requirements, so they would never be able to get back on the roster. However, with this victory, they would, right? So if a firearm falls off the roster and that manufacturer wishes to just circle around and put it right back on, they could just put it back on, right?
That's correct. Within the last few years, some fairly popular HK models, some Smith & Wesson models, they fell off the roster for the kind of ridiculous reasons that the roster regime allows DOJ to decertify pistols for. And those guns would be great candidates for readmission if we get the relief that we've asked for here. But yeah, the deletion provision, the provision that tells DOJ to remove guns for every one compliant gun added, that necessarily can't be enforced if the relief that we've obtained sticks, because that deletion provision only applies if the operative provisions for admission apply. So if those operative provisions don't apply, well, then the language of the deletion subdivision of the statute can't apply either. Now, we asked Judge Carney in our briefing, we pointed out that, look, if you really want to get into the details here, while you're at it, while you're enjoining subdivisions, I think it's 4 through 6 of Penal Code Section 31910, go ahead and enjoin subdivision 7 to B7, because that's a deletion provision. That would just kind of erase any doubt in anyone's minds. But Judge Carney, unfortunately, didn't do that. But in any event, legally, it doesn't seem to make one bit of difference, because if you read the statute, it seems to be fairly clear that you wouldn't be able to enforce a deletion provision.
Well, bringing up the DOJ actually kind of brings me to the end of my roundabout scenario here. That's the one thing that you don't really see in the text, in the law, in the complaint, in anything. We've seen a lot of issues with the Department of Justice, however, and all of these handguns getting onto the roster would have to go through the Department of Justice, right? Can you explain to me, because I'm not very educated on it, what is the process for manufacturers to get their firearms onto the roster? Is this something, we've seen issues with processing background checks for FFLs, for COEs, just not a whole lot of response from the Department of Justice, lots of lag time, which has put a lot of people in serious trouble. If you don't have an FFL or a COE, you can't run your business. Do you see a similar issue bottlenecking at the Department of Justice trying to get in the firearms on the roster, especially if there's a huge flood of them all at the same time?
That's a great question. So in the state's briefing to the Ninth Circuit, they've said to the Ninth Circuit that if you don't enter a stay, the avalanche of administrative work that they're going to have to process is a serious reason why the court should provide a stay, right? That they're arguing that there's going to be a 10-year backlog, basically, right, of guns that manufacturers are going to ask the DOJ to process. Now, that is kind of a ridiculous argument to make, because we're talking about a constitutional right, and the state can say, hey, it's inconvenient for us to do what we need to do on our end so that you can exercise your constitutional rights. I mean, it's kind of absurd. So any liberty-minded jurist is going to reject that and probably laugh the way that I laughed when I read it. But it's true, right? There are some administrative obligations, and the state it's not totally illegitimate to say, hey, look, like what we have to do to follow our legal obligations, right? Because the state has to do what the law tells it to do. And if the law tells it to do things that create a burden at scale, well, that's not a completely ridiculous argument. But on the other hand, the state doesn't really have to do the heavy lifting. The state isn't running the laboratories that do the fire testing. Like, I think each gun has to be fired 600 rounds. It has to basically have no malfunctions, or less than a handful of malfunctions. And it has to be drop safety tested. But the laboratories that do that are not in California. They're not operated by the state of California. They're in Illinois and they're in Maryland. And they do the heavy lifting. So the heavy lifting is done to certify the actual requirements. And then the state basically receives a $200 check. And from what I can tell, just enters it into the roster. That's it. It doesn't sound like a lot of work. I mean, I know there's a lot of firearms out there that manufacturers are going to try to introduce. It's probably into the thousands. And I would imagine that, in the event the Ninth Circuit doesn't issue this stay, they'll inundate the DOJ and the labs. But I think the bigger issue is actually going to be the labs. I think that the labs, there's only 2 of them. I don't know what their capacity is to process guns, but it takes a while to fire 600 rounds out of a gun. So I think it's going to take a while for the labs to process these. So I don't think the burden actually is going to fall to the DOJ. I think that the bottleneck is going to be at the labs. And then as the labs process the guns and certify them, well, then they'll trickle into DOJ. And that's going to be an accelerated trickle than what DOJ is used to, because right now there really is no trickle, because not that many guns are coming at that often they're just not coming in that often. So I don't think the DOJ's argument about administrative burden is legitimate. Now, it's the government, and like you were saying, we know that DOJ, Bureau of Firearms, likes to take their time on things, and that's unfortunate. And I would expect them to take their time on this, but I don't think the bottleneck issue is really with DOJ. I think it's with the labs.
Okay, well, I'm also kind of curious on another level. This decision being dropped was kind of a surprise. We're all on our toes waiting for Judge Benitez to give us a decision on Rhodey and Duncan and Miller, and then this one just drops. And it seems like, or at least it feels like, that these cases are moving through the court system a lot quicker than they used to. So I guess, is there any sort of expectation that you have going forward with this one being at the Ninth Circuit? Or is this just sort of a stigma because we have a couple of cases that have taken so many years? This one happened so quickly, or was it just a specific judge? How is it that we got such a quick decision on this one? Is it Bruin that's making it easier? And do we have any expectations on timeline going through the Ninth Circuit?
Sure. Happy to answer all that. So the reason why CRP's other big cases are moving so quickly is because those cases were pretty much already in the appellate posture when Bruin came down. And in our case, like Duncan had a pending petition for certiorari before the Supreme Court, and it was granted. It was granted, vacated, and remanded. And once that happened, things moved quickly because the case has more or less been adjudicated already. And so the task of the courtrooms that are handling those cases, like in Duncan and Rhodey, is really just to apply the new Bruin standard. And luckily, a couple of our cases are before Roger Benitez, and he's motivated to do them quickly. So it's a combination of having the right judge in those cases, plus the fact that the procedural posture of the cases being on remand from the Supreme Court are allowing them to be adjudicated quickly. Now, in our context in the Bolin roster challenge, the reason why it's moving fairly quickly is because of the nature of the relief that we asked for. So we asked the court for a motion for preliminary injunction. Now, that's supposed to be heard on a quick basis, and things are supposed to happen quickly in that injunction context, because the argument that you're making to the court is that there's some sort of imminent harm, and I need the court to give me relief so that I don't suffer that imminent harm. Now, in our constitutional rights context, it doesn't exactly work that way because this law has been on the books forever, but we now have a new Supreme Court Second Amendment case to go litigate our grievance under, right? So we filed a motion saying, look, given the shape of Second Amendment law now, this unquestionably violates our constitutional rights. And so we are entitled to an injunction. And luckily, the district court for the Central District I think it's the Western Division. That's the Orange County Division where Judge Carney sits. Doesn't have too clogged of a calendar, and they were able to give us a relatively quick motion hearing date. And then luckily, Judge Carney ruled very quickly. Judges don't always do that. Even in the injunction context, judges are busy and they take their time. And but in our case, Judge Carney was very, very interested in our case. He asked for extensive supplemental briefing after the MPI hearing. He gave us a 2-day hearing, took a lot of testimony, asked incredible questions, really gave us just a fantastically comprehensive treatment, and then issued a ruling very quickly, which he didn't have to do. But he wanted to because he understood this was really an important public policy decision. And he made that clear that he understood that. And so that's why things are happening quickly. The Ninth Circuit stay motion is happening quickly also because of the nature of that motion. So that emergency motion is brought to a specific panel in the Ninth Circuit that's assigned to handle these emergency things and produce results on them quickly. And they told us you have until Thursday at 5 p.m. to get your opposing briefing in. I would imagine they'll rule on the following day, or maybe take a weekend. So that's why things are happening quickly there. Now, as far as the future of the case, we have a trial date on calendar for, I believe, January of 2024. We may see dispositive motion practice, I'll translate that to English. That means that in lieu of a trial, parties have a right to file what's called a motion for summary judgment. And we've done that in other CRPA cases. And what that basically means is that you say to the court, look, there's no need to hold a trial. All the facts, all the evidence, they're already settled. So you kind of have a trial on the papers. You write a big fancy essay for your judge and say, hey, look, enter judgment in my favor. Sometimes the state will file a dueling motion for summary judgment, like it did in Duncan. That could happen here. We don't know. Our focus right now is on the MPI briefing, and after that chapter's over, we will revisit what to do. I think Carney would like to see a trial, but that's just my speculation. He he was very involved in the NPI hearing. I think he understands the issues very well. He sure seemed to. He asked a ton of questions. He really wanted to understand everything about this case. So we'll have to see what happens.
Well, we are certainly very excited to see where it goes, and hopefully, I know we all got our fingers crossed because we all got those people out of state that have some of the firearms that we want. So hopefully this can get moving soon. We're certainly going to keep our eye on it. Alex, thank you so much for coming on and providing this context for us. Really appreciate having you on.
Hey, it's my pleasure. It's been fun speaking with you, and I'm happy to join you anytime.
Yeah, definitely. In the future, we can get some more updates going, and we want to continue updating you. So please like, share, and subscribe to this channel. It really helps get the information out there, and it creates notifications for you when CRPA TV drops a video. We want to keep you as up to date and informed as possible. So please, one more time, like, share, and subscribe to that channel. We have almost reached our goal of 10,000 subscribers. Thanks again, guys, and we'll see you on the next one.